Which one do you want to do first, the motion to exclude or the motion for summary judgment?
Your Honor, we'd like to start with the motion to exclude Dr. Davis.
Okay, let's proceed.
Your Honor, this case is regarding an incident that happened at the Baylor Scott and White Hospital in Marble Falls in 2017. Mr. Bostic was exiting a door into the lobby.
I'm very familiar with the facts.
Okay, and I wanted to clarify some points on the facts of the case. So what I'd like to do is share my screen with you and play the video for you so I can clarify a couple of things that I think is important for the court's consideration.
Okay, go ahead.
Okay, Your Honor. What I'd like to do is play through the incident.
I'm sorry, Rico is able to join us, and so let's deal with him first.
Okay.
Are you there, Rico?
Yes, it's connecting.
Oh, he's not connected yet. Okay. Is he connected? I can't tell. Rico, are you there? Ricardo? Can you guys hear me okay?
Yes.
I can't tell. Is he here or not? I can't tell. It shows him as a participant.
It still says connecting to audio.
Okay.
There you go.
Hi, Judge. I'm on the phone line.
Okay, good. Hey, thank you for joining us. We have a case that is set for trial next Tuesday. It's a pretty extensive case, and we have some time limitations. And so we were thinking of starting jury selection on Thursday instead of next Tuesday. But I was wondering if you had a sense of how many jurors we could get on Thursday. Kind of what is your experience with Thursday summons?
Not a problem. Let me check next Thursday's.
That would be this Thursday.
So the 14th?
Yes, the 14th.
Let me look at about 100 and we have no cases as of right now. So your case would be the only case.
Oh, good.
Good. It looks like we have 130 confirmed,
Okay.
which means that we'll probably get half of that in attendance also, because that doesn't account for unqualified jurors. So we should have, I'd say, somewhere just under 200
Just under
for
what?
Thursday. We'll have just under 200 jurors in attendance on Thursday.
Okay, so we could get a 100-person panel then.
Easily, as of right now, yes. If I get the email, I can create it, and we can meet that request.
Would we have a better shot at giving a 100-person panel on Thursday or next Tuesday?
Probably Thursday. Tuesdays are just like Mondays. They fill very quickly. Like, yeah, we typically need about 300 to 250 jurors on Mondays and Tuesdays.
Okay, because the other judges are taking that.
Exactly. Wednesday through Friday, it's pretty open. If we give enough notice, yes, we can manage a panel of 100 on a Wednesday, Thursday, or Friday if needed.
Well, let me ask this real quick. Mr. Carter, you kind of expressed a concern about going forward on Thursday. Given kind of what we've heard, are you okay with going forward on Thursday, or kind of how can we accommodate your concern?
Well, I want to talk to my co-defendants counsel and talk to my client, because I must say, having just got out of a trial on Friday for a month in Judge Tobolowski's court, I'm getting prepared this week for this case.
Okay.
So this Thursday and Friday is going to be my preparation days, and my witnesses coming in on Sunday. So that's a concern that I have, and I'm sure the other co-defendants have that. So
I just want to make it clear, we're not doing any testimony. We wouldn't do any testimony this week.
I understand. I understand.
I guess my question is, and I'm not trying to put you on the spot, is that if we go forward on Thursday, we had noticed this for next Tuesday. I see this as kind of having two options. One is we do time limits for next week. I'm trying to avoid that. I'd prefer to start on Thursday. And given that we could get enough jurors, I think that's a big plus to doing Thursday besides just the time concerns.
So we
Right.
start on Thursday with questionnaires and then come back and do voir dire on Friday. Is that what
Right.
okay. If my co-counsel are okay with that, I'm okay with it.
Anybody have a strong objection to doing it this way? I can't hear you. Ms. Atwood, are you speaking?
Yeah, trying to get off mute. I don't have a strong objection to doing that. I have some of the same logistic concerns because I just got out of a trial about 10 days ago. So I've been scrambling to get up to speed. But I think given the court's time constraints with the 8 days that, we need to be sure that we're done. I would ask if we could do pre-trial on Friday after voir dire, because it sounds like we've got a fairly short voir dire process if we're going to have.
How about we do this? Let's do just the motion in limine on Thursday before we start, because I have to have that done before we do jury selection, before even questionnaires really, and then let's do the rest on Friday. How does that sound, Ms. Atwood?
Yeah, I think that can work, Judge.
Mr. Carter, how do you feel about that?
Okay, we'll do it.
All right, so we'll go ahead. Rhonda, go ahead and send the email to Central Jury Room. Rico, thank you so much for joining us. We're gonna need a 100-person jury on Thursday on the Bostic case. And we will see you guys on, Thursday.
Sounds good. Thank you, Judge.
Thank you, guys. All right, let's get back to the motion to exclude.
Okay, thank you, Your Honor. Your Honor, so I'm going to play through the video for you and make a couple of points to you after the incident occurs. And I've slowed this down for you, Your Honor. And Your Honor, you'll see right here, this is when the incident actually occurs. And Your Honor, at the point in time when this accident occurred, the door was activated to open either by a push plate or someone that we can't see in the video. And I want to be 100% clear. The plaintiff's theory of causation has nothing to do with the incident and when someone activated the door to open. It is undisputed and agreed upon by all parties and experts that the accident and the sensors specifically were not designed to be, nor were they active at the time the door was activated to open and Mr. Bostic fell. So that is completely irrelevant to this claim. Rather, plaintiff's claim is that this accident occurred when Mr. Bostic was exiting the door and the door began to close. They claim that a sensor was improperly set. However, in order to make that theory be true,
Can you give me 1 second? I'm sorry. Okay, go ahead, guys. There's one of your co-counsels is here. Did you want to make an announcement?
Sure. Joshua J. Bennett here on behalf of the overhead door defendants.
Were you able to hear that, Tony?
Yes, Judge.
If you're going to say anything, if you could just come over here so that she can see you. All right, go ahead, Ms. Atwood. I apologize.
Oh, it's Ms. Cheek, sorry. Yes, Your Honor. So this accident actually occurred, and plaintiff's claim is that the cause of this accident was not at the point in time that you see on the video. Rather, they claim that when Mr. Bostic exited the door, that the sensors should have picked him up and not started to close. Therefore, he wouldn't have to grab the door. This requires two assumptions on behalf of their expert, Dr. Davis. First, he has to assume where Mr. Bostic was standing when the door was operated to open when he started to exit, then he also has to assume where Mr. Bostic was standing when the door started its closing cycle before this surveillance video picks up. Additionally, and most importantly, in order for Dr. Davis's opinions to be true, he has to disregard the surveillance video evidence that shows that the subject door, the in-swing door, was closed. And Dr. Davis admits on his own that these doors, there's an in-swing door and an out-swing door, the out-swing door being to the lobby side of the ER. These doors, when operated under power, meaning someone either pushes the push plate or operates the door with the push button at the nurse's station, the doors open simultaneously, they hold open for a certain amount of time, and then they close simultaneously. Dr. Davis, to give his opinion, has to disregard the video evidence, and I'll show you a zoomed in version of this video that shows that at the time that this video picks up, in the surveillance video, that the in-swing door into the triage area is closed, which means that Mr. Bostic must have manually pushed through that door. Dr. Davis admits in his own testimony, they did not consider any of this. And I'm going to show you the enhanced video that shows that how you can see, and this is from a video that we did during an inspection, Your Honor. And it's in comparison to the video from the surveillance footage. Okay. So, Your Honor, you'll be able to see that the in-swing door was closed, and this is the video on the left-hand side from the surveillance video from the actual accident, and you'll see that the door on the in-swing side can be seen opening and closing in the enhanced video, which means that the out-swing door must have been manually pushed through by Mr. Bostic. Given that the in-swing door into the ER side was closed and there's evidence Mr. Bostic must have pushed through, Dr. Davis must consider that in order to be reliable. So as you're fully aware, the expert standard is that the evidence must be sufficiently tied to the facts of the case that will aid the jury in resolving the factual dispute, and that's from Robinson. And what we're concerned about here is the third prong of the reliability test that's set forth in defendant's motion. And that is that there has to be a connective reliability between the expert's opinions and the actual facts of the case. Now, you're going to hear a lot about Dr. Davis's credentials, but as cited in defendant's brief, the claim will not stand and fall on the mere ipse dixit of a credentialed witness. So the fact that Dr. Davis may be MIT educated and has degrees in engineering and physics is irrelevant to whether or not his opinions have sufficient reliability for purposes of this case. When Mr. Bostic pushed through the door, it is undisputed that the sensors, not a single sensor, had any role in this case. If Mr. Bostic pushed through the door, as defendants claim the video shows, the sensors play absolutely no role. With respect to Dr. Davis's opinions, he admits that he did not consider whether or not the subject's in-swing door was closed or not, and never gave any consideration whether or not Mr. Bostic pushed through that door. And I'm going to show you page 13 from his deposition, where he clearly states that he did not consider whether or not the in-swing door into the triage area was closed. So if you look at page 13, at the bottom, he states on line 19, the questions, and are you prepared to offer any opinions about what the door, what position it was in before the video starts? Only to the extent that it would approximate the operation of the other door, the left-hand door, the one that we can see. Question, do you have any opinions about whether the in door was open or closed just before the start of the video? I would say that it was open just before the start of the video. And by the way, I cannot, excuse me, but we cannot see the right-handed panel in the video. We can only see the left-handed panel. But they are synchronized. They work together, but in opposite directions, as you already pointed out. And then question, so your position is that you don't think the door can be seen in the video? Response, I don't recall being able to see it. Dr. Davis did not even consider the location of the in-swing door when he gave his opinions, because he claims that he could not see it, or he doesn't recall that he could see it. Whereas the video, as we've shown you, clearly shows that the in-swing door can be seen, and it can be seen moving to open after the accident occurs, and also shows that it was shut at the time that the video picks up. Additionally, Dr. Davis admits on page 23 and 24 of his deposition that if Mr. Bostic had manually pushed through that door, that the sensors would not be in operation and would have no role in this incident. And he also admits on page 23 and 24 of his deposition, as we've cited, that you would be, his body would be centered through like he has seen in the surveillance video. Your Honor, I would point you to the cases that we cited in our brief that clearly say that in order to be reliable, that you have to disprove alternative theories of causation. Otherwise, the proffered opinion is speculative and conclusory. And that's from the Walmart versus Merrill case. Additionally, again, the Supreme Court in Keller versus Williams also said that you cannot disregard contrary evidence by showing that the witness was unqualified by giving the opinion. Additionally, it says that you have to have facts that show that your alternative theories are not accurate. And then finally, I would point you to the Bustamante case, which also says that you have to disprove that other alternative theories were the cause. Specifically, it states, when the evidence demonstrates that there are other plausible causes of the injury or condition that could be negated, the plaintiff must offer evidence excluding those causes with reasonable certainty. Here, plaintiff in their response just states that the video does not change Dr. Davis's opinion and is not inconsistent with Dr. Davis's opinions. However, plaintiff did not attach a single affidavit, a single piece of evidence, or any statement from Dr. Davis that refutes what he saw in the video. Rather, the only testimony you have from Dr. Davis is that he did not consider whether or not that in-swing door was open or closed at the time that the video picks up. Based on that alone, we believe that Dr. Davis's opinion should be stricken as unreliable.
Response?
Oh, I have one additional point, Your Honor.
Okay.
Even if you were to disregard the clear video evidence that the in-swing door was open, Dr. Davis's opinions on the calculations, as outlined in our brief, should also be stricken because they rely on multiple assumptions that we just don't have evidence of. That first assumption being where Mr. Bostic was standing when he asked someone to allegedly open the door for him before he exited. And then second, where Mr. Bostic was standing when the door began to close. There's no testimony to support where that was. Without that, Dr. Davis's opinions are solely based on his assumptions and his conclusions. And I believe that's all we have for now.
Ms. Metcalf?
Yes, Your Honor. First off, I want to pick up where Ms. Cheek started. She claims that his opinions are not reliable because he did not determine where Mr. Bostic was when the door was activated. What Dr. Davis has testified to, and we've provided the page and line in our response, Your Honor, Dr. Davis looked at where Mr. Bostic was in the surveillance video, using the video she showed you, looked at where he was when the door was closing, looked at the trajectories, looked at the timing using walking speed numbers as set forth by the Texas Department of Transportation. He actually even cut back from, the U.S. Department of Transportation, and he actually cut back from there because they estimate walking speed at 4 feet per second. He even made it slower to 3 feet per second to 2 feet per second because my client, Mr. Bostic, is an older gentleman. So he even made it slower just so we could get a range for where to show where Mr. Bostic would have been when the door began to close. It's technology that is used, for instance, in GPSs. You look at where, and actually I heard an example about when you're predicting where an asteroid is going to hit or where it did hit, you look at you get that pinpoint and you count backwards from there. And that's what Dr. Davis did. He looked at the point and he counted backwards. We have provided those calculations. They're attached to the response as Exhibit D. The defendants all had those at the time of his deposition. They had the information, they had his calculations. So that's what he did. It's his opinion, and this makes sense, that he doesn't need to know where Mr. Bostic was specifically when the door was activated. We know from the testimony that's undisputed, Mr. Bostic was between two sets of automatic doors in a hallway. And his testimony is that he asked the nurse to automatically activate the doors to open. That is undisputed. So we know he was in that hallway. We know he wasn't up on the roof or anything like that, but where he was specifically in inches is not important to his opinions, because he has taken where he was on the surveillance video, on the objective evidence, done calculations for the angles and pulled him back. That's the foundational reliability of his opinions. And it's based on things like the US Department of Transportation's walking speeds, laws of physics. We've set that out in our response, Your Honor. So we did address Ms. Cheek's argument that he did not calculate where he was when the door began to close. And he gave a lot of testimony about that. And I'm happy to pull it up if you want to see it, Your Honor. He did not give testimony, and we acknowledge that in our response, as to where Mr. Bostic was specifically when the door was activated, because that is not part of his opinion or pertinent to his opinion. He knows generally he was in the hallway because he asked the nurse to open the door. Okay, so that's not a part of his opinion. We acknowledge that. We're counting back from when the door starts to close. So the other piece to Ms. Cheek's argument that I would like to address is this whole idea that this video somehow proves that the door was manually pushed open. It just doesn't. And Your Honor, the Supreme Court in Gunn v. McCoy held that jurors are the sole credibility of the expert witnesses and the weight to give him testimony, because in that case, like here, we're going to have a battle of the experts. That's what's going to happen. And the court said that the assumptions are unreliable if they're based on assumed facts that vary from actual facts. And here, Your Honor, if I could show you a video, I think it would help explain this.
Okay.
All right, so Ms. Cheek's and the defendant's position is this door, if you look at this video, the door on the right-hand side, if it's closed, then there's no way that this door was opened automatically when the panel on the left begins to close, or is shown in the video closing. And if I can play this, Your Honor, this is a 38-second video and I will stop it, but this is going to show the door being automatically activated. In other words, no one's pushing through it. All right, and I'm standing alongside the left-hand panel as Mr. Bostic is when you first see him in the video. And his testimony is he walked to that panel and he called out to his pastor and was talking to his pastor, calling him. And as you can see, Your Honor, the door can close on the right-hand side while the left-hand panel is still open, and that was opened automatically. And we see that one of the issues here, Your Honor, and you're going to hear more about this, is the video of Mr. Bostic actually exiting these doors has never been produced. There is no evidence except Mr. Bostic's sworn testimony that he asked the nurse to automatically activate the doors for specifically how these doors were opened. We show in this video that the doors can be automatically opened and the right-hand panel automatically closed while the left-hand panel is still open. That's what Dr. Davis has based his opinions on, and that's what why he's saying what they show with the panel closed, it doesn't affect his opinions. He still has the same opinions. There's nothing that has changed. His opinion is still that Mr. Bostic was standing alongside the door when the other door and when the other door became closed. But let me back up, because one of the page in line she said is, well, you can't tell us if this door was open or closed when Mr. Bostic was standing next to the panel or something along those lines. And I don't have her page in line pulled up here, but
Ms. Metcalf, let me just ask you the main thing I'm concerned about, which is
absolutely.
the only argument that really is at all persuasive to me that's been made in this motion is the idea that you have an obligation to rule out, essentially based on reasonable certainty, other plausible explanations. Tell me how you've done that.
What Dr. Davis did that from the get-go. When he looked at this video, he looked at it and said, okay, this door can be closed while this door is open. And they had the opportunity to depose him on that. They had all of these videos when they deposed him. Those have been his opinions from the beginning of time in this case, Your Honor. There's nothing in that changed. Now they say, well, we did this enhanced video, which shows that, and there is a question of, does it show that the right-hand door is closed or that the right-hand door is closing? Either way is consistent with the video evidence that Dr. Davis has relied on and that he's based his opinion on. What his opinion also is on, Your Honor, is the fact that the sworn testimony in this case, the only sworn testimony, is that these doors were automatically activated. No one has contradicted that testimony. They produced a video, but no one has said, no, we've got testimony that, he did manually push these open, or we have sworn testimony that he did so. That's just not contained in the record.
Let me, any of the defendants want to counter that?
Yes, Your Honor. I will say that the evidence is not as clear as Mrs. Metcalf would make it seem. Mr. Bostic was not clear on what he was doing. And additionally, I just want to clarify, Dr. Davis did not consider, as we pointed out on pages 23 and 24 and 13 and 14 of his deposition, whether or not that in-swing door was closed or not. There is no evidence to any degree of certainty that disproves our alternative theory. The only thing you have is Ms. Metcalf's own argument that it didn't change. But where's the affidavit? Where's the evidence? Where's the proof from Dr. Davis that he has excluded this theory to a reasonable degree of certainty? And if Your Honor would allow, I have a response to her video that she showed you as well.
I don't need to see any more videos. I'm going to go ahead and deny the motion. Let me take a real quick break here. All right, let's deal with the summary judgment.
And Your Honor, I'm going to hand it over to Mr. Downey to handle the summary judgment.
Okay.
Morning, Your Honor.
Morning.
So we've already kind of touched on some of the issues, but without getting too into the weeds, we represent Door Control Services, LLC in this case. And we put forward a motion for summary judgment, a hybrid motion, one part, no evidence, motion for summary judgment as to duty, no evidence as to causation, and then traditional as to conclusively, disproving causation and conclusively disproving any duty on failure to warn. In response to our no evidence, and Mr. Kita brought this up in his his response to the no evidence, we should take that up first before we get into the traditional. The plaintiffs wholesale failed to produce any evidence at all. And I'm just like, if you go through the 10 pages of legal argument they make as to duty, there's no evidence at all as to what DCS's role was involved in any of this. And the court is making a legal determination as to whether a duty should be imposed. That's textbook Hornbook law in Texas. But the court has to make that determination as to whether a duty is imposed from the facts surrounding the occurrence in question. And that's what the burden of proof in a no evidence motion for summary judgment is. And that's like the case. It's Greater Houston Transportation Company versus Phillips, 801 Southwest 2nd, 523 at jump page 525, Texas Supreme Court, 1990. If your honor has reviewed the response to the no evidence motion, Mr. Cheatham makes 10 pages of legal argument. Mr. Bostic, through his counsel, makes 10 pages of legal argument as to why a duty should be imposed. But they haven't actually attached any summary judgment evidence, no depositions, no interrogatories, no affidavits, no competent summary judgment evidence at all that would allow the court to infer a legal duty should be imposed on DCS for whatever it is that's been alleged here. Now, I say it that way because they don't, when we flip over to the causation argument in a second, they don't actually say that DCS did anything wrong with respect to proximate causation or cause and fact. There's no reference in the affidavit in the causation element that says DCS did X. This, whatever they did was the cause of Y. There's none of that in the affidavit. In fact, in the causation evidence, there's not a single reference at all to Door Control Services LLC. Dr. Davis reviewed some discovery responses that Door Control Services put together, but he doesn't actually point the finger at Door Control Services and say, these guys are the cause of Mr. Bostic's injuries. I would point the court to, Abizaid versus Anani LLC. It's a Dallas Court of Appeals opinion from 2017. The cause number on that is 5-16-00667-CV. The Westlaw cites 2017 WL 5590194. The jump page is 7. The Dallas Court of Appeals took up the issue as to whether they could cite things that have been otherwise presented in the record to the court at other times. The Court of Appeals said you can do that, but you actually have to incorporate some reference into the response for the motion for summary judgment. You have to come forward and make a reference or anything that ties the evidence that you claim might be in the record to the element that's been challenged on the no evidence motion for summary judgment. That hasn't been done. None of that was done. And I would direct your honor to take a look at the response on pages 1 through 11. There's not a single evidentiary cite at all from pages 1 through 11 of the plaintiff's response to the summary judgment as to duty. They don't take up the failure to warn there. They just say you didn't prove it. And I'm like, again, maybe not, but you have to come forward with some evidence to controvert the matter. And that's the thing. You have to create a genuine issue of material fact on the element. They simply haven't met that burden because they haven't come forward with the evidence. That's for the duty element. For the causation element, the same thing is true. Dr. Davis's testimony that he gave in his affidavit, which there's been 2 depositions of the man, and the deposition testimony simply wasn't attached to the summary judgment or otherwise referenced in the summary judgment. The affidavit that's been presented references 2 of our other co-defendants, Baylor, Scott, and White, and Overhead Door, but it doesn't say anything about Door Control Services. And I think at a minimum, if you're going to come out and say we have evidence of causation, the causation evidence should point the finger at a potential defendant and say they caused the injury. This is just not present in the evidence. Yeah, and I'll turn then to the traditional motion for summary judgment. They've alleged a failure to warn as against Door Control Services. The summary judgment evidence that they did come forward with conclusively rebuts their own position. The summary judgment evidence, the declaration of, or the affidavit of Mr. Davis or Dr. Davis, there's 2 failures to warn. One is that somebody should have alerted Baylor, Scott, and White to the fact that there were supposed to be daily safety checks on the doors. All right, may I share my screen real quick, Your Honor?
Sure.
Okay. Can you see the signed affidavit of Dr. Davis there?
Yes.
All right, the highlighted portion, this is the only issue that takes up this failure to warn, and it says, had Texas Access Controls placed the daily safety check decal on the door at issue in this case, it is likely would have served to notify the technicians at Baylor, Scott, and White that daily safety checks were needed. So the summary judgment evidence clearly places the burden of proof on somebody, the causation element on somebody else, and it places the duty element on somebody other than Door Control Services. This is a DBA used by one of the other defendants. It doesn't do it as to Door Control Services LLC. So the summary judgment evidence just fails wholesale to demonstrate that failure to warn on the part of Door Control Services was the cause in fact and the proximate cause of Mr. Bostic's injuries. And to
let me ask this.
Yeah.
This is directed to Mr. Kita. I'm a little confused, and maybe I'm reading the wrong document. To be honest, I thought that we only had the motion to exclude set for today, but apparently the summary judgment was set. I just didn't see it. I've looked at the summary judgment response. It doesn't look like you, at least what I think is the summary judgment response, it doesn't look like you attach this affidavit to the summary judgment response, and that's not usually how this is done. So, Mr. Kita, it looks like you're the one who drafted this. Kind of explain to me your thought process on why you didn't attach this affidavit to the response, or did you? And I just missed it.
Your Honor, I think you may have missed it there. What I did was sort of kind of like the procedure we use in the Northern District, where rather than just have a summary judgment response that has 200 pages, of exhibits to it, I draft a document that has the legal reasoning, and then I have an appendix, and then I cite directly to the appendix, so it's easier for the court to find.
Okay.
So Dr. Davis's declaration or affidavit
is that what he did?
Yeah, I don't dispute the fact that Mr. Kita put into the record the appendix. He did that. He put in the appendix both this affidavit from Dr. Davis and testimony from our expert, or I guess one of the other experts.
Mr. Kita, I get why you do that. It's probably because of the quote local rule we have about page limitations on summary judgments, which I don't ever enforce. I don't think it's actually enforceable, but I just didn't get that.
That's good to know for future reference, by the way, Judge. Thanks.
Yeah, I've never enforced that a single time, but I know a couple of judges, I guess, apparently still do. So, and it's not, and people have attorneys have pointed out to me that it is not the local rule, and I totally agree. It is not a local rule. It's mischaracterized on the county's website. But all right, anything else, Mr. Downey?
Yeah, I would just, with the court's concern about this appendix issue, I don't dispute that we received the appendix or that we properly filed in the record. My problem with the motion for summary judgment response and the appendix together is that neither one of the two of those documents, the evidence and the document, arguing the response, neither one of the two of them put any evidence forward on causation. And like I said, any duty at all. Like I stated earlier, without beating the horse, the entire first half of the response to the motion for summary judgment is bereft of any citation to any evidence anywhere in the record, to the appendix or otherwise. And if you're going to come and tell me that there's a duty that needs to be imposed, I think, Your Honor, you've got to put some facts behind that duty, or else you don't meet your burden for the element. And with that, Your Honor, I'll cede my time.
Mr. Keeter, Ms. Metcalf, do you want to respond?
I would prefer not to be pinned anymore. This is Mr. Kita's response.
Okay, sorry.
Great. Thank you, Judge. Okay, I think there's no dispute that Door Control Services provided services to the doors that are at issue here. If my response motion lacked a footnote to the 15 times in their own expert's deposition that referred to the fact that Door Control Services serviced these doors, that's my fault. That doesn't mean there's no evidence in the record. The principal argument that was in their motion was this frequently argued and always wrong theory that somehow the Supreme Court's case in United Scaffolding versus Levine means you can go onto somebody else's property, commit acts of negligence, and then be impugned for any damages whatsoever, because you're like, hey, there's only two kinds of negligence. There's premises liability and negligent activity, and we weren't contemporaneously negligent when this injury occurred, so it's not negligent activity. And we didn't own the place, so we're not premises owners, so we're free from negligence. And that's the argument that you rejected in the overhead door defendant's summary judgment motion, and that's the argument that I believe you should reject in this one as well. If I failed to include a footnote that showed that door control services came onto these premises and serviced these doors, that's my bad, but that's not that's a ticky-tack distinction that I don't think should govern whether a defendant should be wholesalely dismissed from a lawsuit when it's absolutely undisputed as to what their responsibilities were here. So without beating a dead horse, there's a duty here. There absolutely has been a duty. The Supreme Court's recognized this duty for 50 years. The argument that United Scaffolding versus Levine controls here is preposterous. You rejected it already. You should reject it again. Our causation argument is based on the exact same things that Ms. Metcalf just went over. It's a battle of the experts. Our expert suggests that the overhead door and door control services violated the ANSI standards, that I'm not going to reread my motion into this evidence. The court reporter doesn't want that
I've taken
either.
a look at it. I'm going to go ahead and deny the motion. I think it's consistent with what I've done before. Is this the proposed order that I should sign?
No, Your Honor, that looks to be one for overhead door defendants.
Okay, I'm sorry.
So it would be very similar. You could just cross out that.
No, did you submit one for this one? I just don't see it. There's so many things filed.
Your Honor, I would have to, let me check with my staff real quick.
And Your Honor, if there's not one filed, I can get one to you in 45 minutes.
Okay, go ahead and just share. Go ahead and get that to me by this afternoon. We will see you guys on Thursday. Please reach out if it turns out that you need to, or do you know that we're starting the trial on Thursday?
So that's what I came down. That's really hard for us, Judge. I'm upstairs on the 8th floor trying to get a verdict after a 5-week trial. I don't know that I'll have one by then. I've got to participate in board. I got to help my team. I've already in 1 hour of deliberations, 3 jury notes have come out. To move it up like that really puts us in a bind with not enough notice to really adjust. I don't think that's fair.
You weren't here. We had a very long discussion about this. I'm sorry you weren't here for this. Y'all want to talk with him? Who's your co-counsel?
Me, Leon Carter. That's what I was saying, Judge.
I mean, I get it. It's a stressful time right now with COVID kind of ending, and we're having back-to-back trials. The court is in the same situation. We're in back-to-back trials as well. I know it's not quite the same, but you guys talk about it. If you guys all come up with some other proposal, time limitations or something like that, that everybody can agree on, I'm happy to do that. But we already heard from the central jury room that we're not going to be able to get enough jurors on Tuesday. We can get enough jurors on Thursday. We're only doing jury selection on Thursday and Friday. So it's just, I know it's not ideal, but we live in non-ideal times.
It's not just not ideal, Your Honor. It's prejudicial. That's the problem. I'm coming out of a 5-week trial into another one, and we already sort of
Mr. Carter is a very able
he
co-counsel.
was part of that same trial. He'll have to be there when the verdict is read. We can't read a verdict on Thursday and pick a jury too. I understand the court's problem, and I understand all that, but if we get a verdict sooner, maybe it alleviates it, but we can't provide any guarantees, and I can't sit in suspense with Mr. Carter on the 8th floor while we're trying to also pick a jury.
So what is this? I thought, Mr. Carter, you were done with your other trial. Is there another? I'm confused on what he's talking
No,
about.
we finished the evidence on Friday, went to the jury on Friday. They came back today.
So they're deliberating at present. If they don't come back with a verdict, and after literally 1,000, I think it's like close to 1,000 exhibits that they've trolled through, and testimony and 5 weeks worth of evidence, I'm not going to be shocked if by Wednesday we don't have a verdict. And so then we get one on Thursday while we're trying to pick a jury, and Mr. Carter's what? In the middle of his examination, he's coming down to read the verdict?
let's just let me know what happens, I guess. If that case is still, if you don't get a verdict by Thursday, then we may have to address it. But I don't know how else we could, I don't know how else we do it. We have 100-person, we can't get 100-person panel next Tuesday. We have we have 8 days. Let's figure it out. So you guys let me know if you can't work it out. And if you don't get a jury verdict by Thursday, then we may have to move it.
Well, can we say by Wednesday? 24 hours notice, Judge, come on. That's harsh.
I'm not trying to be harsh. I'm trying to balance everything out. We had a huge discussion about this and you weren't here for it. Mr. Carter spoke ably on your behalf, but we're juggling a lot of different things here.
Understood.
So sorry.
It's not fair. It's not fair. Sorry, are we excused, Your Honor?
No.
I'm apologizing.
Why don't you come back here? I don't want you to be angry. So tell me, you're obviously very frustrated because you're in the middle of another trial. You wouldn't
Yes.
normally act like this, I'm sure.
I don't. I've gone through-
You're being very disrespectful. I don't think you mean, I don't think you mean to be like that.
I'm not meaning to be. I thought we were off the record of having.
You're on YouTube right now and on the
Oh.
record. So that behavior is not acceptable in this court.
Understood.
So let's kind of dial it down a little bit, okay? So how do you propose we deal with all of these issues? Do you want to do time limits?
I would be more in favor of time limits, given especially that this is a trip and fall case that should be able to be tried in those 8 days that Your Honor's provided. So I would be far more amenable to having time limits than I would be to having jury selection several days sooner than anyone on my side thought.
Do the other defendants agree on that? If we'd have equal amounts for both sides. My understanding is that the defendants were concerned because your line and page designations were a lot longer.
I think the answer that Your Honor suggested, that we try to work it out and see where it falls, is fine. I apologize for the frustration to the court.
Hey, I've been in trial. I think you're still stressed out from what's going on up there.
That's absolutely the case.
So, and I maybe I'm not following. Mr. Carter tried that case with you, but
Correct.
he's not there right now.
No, he's back at the home office while I take jury notes and deal with appellate issues.
Is it possible, Mr. Carter, that you could do jury selection? And what is your name again?
Joshua.
Mr. Bennett. Does Mr. Bennett need to be there for jury selection on Thursday, or I just don't know enough about how you guys are dividing this up?
I think what I tried to indicate before, Judge, and I can't see anybody, so.
Mr. Bennett, why don't you come over here so everyone can see you?
No, I mean, the order denying overhead doors motion is still on my screen. I can't see.
Oh,
it.
let me do this. Let's stop sharing. How about that?
Okay, there we go. Thank you, Judge. I think what I had indicated is that I was getting prepared because I had been in trial for 5 weeks, and that Thursday and Friday were going to be my preparation day and meeting with my expert, meeting with witnesses and things of that nature, and that was going to cause me some consternation. But if the other defendants could do that, I would try my best to do it. But I am going to be the one who's going to pick the jury. There's no doubt about that. I'm going to do that. But it's just, I mean, I didn't expect this today.
And that's the issue. What Mr. Carter just said, we've been in trial straight for 5 weeks, haven't been able to meet with witnesses. We've had associates doing ably, but at some point, all team members have got to be involved. Usually when you're going to pick a jury, you have all counsel present, Mr. Bennett, so-and-so. I can't be in 2 places at once. And typically the rule is, if the person isn't there to be introduced to the jury, they're not part of the trial team. Waiving that rule.
That's not a rule. I can explain to the jury what's going on if you're not here. I'm not going to say that you can't be part of the trial team, because in the unlikely event that I don't know about how Judge Tobolowsky does this. I've been doing this for 16 years, so my 16th year on the bench, and I've only had one case where we've had over 3 days of jury deliberation. And so I don't know anything about this other case. Maybe it'll take that long, but I would really doubt that you're still going to be in jury deliberation on Thursday. But I obviously can't guarantee that. I'm open to suggestions. I've told you my situation. You know, why don't you guys talk about it? If there's some other way you want to do it, if you guys want to do time limits or something like that, we can do that. You know, maybe if you guys could agree to a 6-person jury, we won't need 100 jurors.
I don't think we need 100 anyway. Why do we need 100? We just need, 50 wouldn't that be enough? Who thinks we need 100 jurors?
We took 30 prospective jurors in Tyler and picked a jury of 8. I don't understand.
This
why we
isn't
couldn't-
federal court, though.
I don't understand why we couldn't do that with this case. It's a trip and fall that happened in Marble Falls.
I think we need to have more rather than less, because we need to do this once right. I think that if we need to leave today, I hope with something solid, because Sally and Matt, the 2 lead counsel that are trying these cases, are coming down from Austin. And so, they really do have to know some certain on what we're doing today, because they're obviously going to have a travel day on top of everything else. And I think we're going to accommodate whatever the court asks, but we cannot be in limbo at the end of.
Why don't you do this? Why don't you guys, I'm going to leave the Zoom link. Mr. Bennett obviously missed a lot of our discussion before. Why don't you guys stay on the Zoom and you guys try to talk it out? If it turns out that you have some other better solution, I'm open to suggestions. I'm trying to work this out within the schedules that I have. And so if there's another way to do this that you guys would feel would be fair and better, I'm open to suggestions. And why don't we, you guys talk as long as you need to. I'll be back around 1:30. Okay.
So will we be back on this Zoom link at 1:30, Your Honor?
We'll be back on this, and you can stay on the Zoom link. I'll turn YouTube off.